Welcome to the Deep Dive, the place where we take the dense jungle of regulations and carve out a clear, navigable path to mastery.
Today's mission is, well, it's foundational, but it's also intensely detailed. We are providing the essential blueprint for corporate existence in India.
And our listener today is looking for that expert-level understanding of how a company is legally born and governed under the Companies Act, 2013.
Specifically, Chapter 2, we're covering the incorporation of a company and everything incidental to it, which means Sections 3 all the way through 22.
Right. And we are going far beyond just simple definitions today. We need to understand the mechanics of limited liability, the absolute power of those foundational documents, the memorandum and the articles,
The MOA and AOA, yes.
and the crucial legal shields that govern how a company interacts with the market: ultra-virus, constructive notice, and indoor management. This is the stuff that takes you from just knowing the law to true professional competence.
Absolutely. This isn't just theory. We are talking about the literal birth certificate and, the DNA of a corporate entity. Every compliance step, every signature on a founding document is a deliberate legal move with some pretty profound consequences.
Okay, let's unpack this. And I think we should start at the very beginning with the people who actually dream up the company, the promoters.
A great place to start.
Who exactly are these foundational figures, and why does the law in Section 269 define them so broadly?
The definition of a promoter is one of the most important concepts because it's primarily designed to assign legal liability.
So it's less about giving credit and more about assigning blame if things go wrong.
Exactly. It's for fraud, misstatements, misfeasance, rather than just recognizing who filled out the first forms. So the law casts a very wide net to capture all the influential individuals.
So what are the specific categories? What brings someone under that promoter umbrella?
Well, a person falls under the definition if they satisfy one of three core conditions, and they all focus on either formal acknowledgement or actual control.
Okay.
First, they're explicitly named as a promoter in the prospectus, the document inviting investment. Second, they're identified as a promoter by the company in its annual return.
So on the public record.
Right. Or third, they have direct or indirect control over the affairs of the company. And that could be as a shareholder, a director, or, through some other means.
That seems fair enough. It covers the obvious initial players. But you mentioned there's a fourth crucial aspect that extends this definition way beyond the original founding team.
That's the critical part. A promoter also includes any person in accordance with whose advice, directions, or instructions the board of directors is accustomed to act.
Whoa. So accustomed to acts, that's a huge gray area.
It is, and it's designed to capture that sort of shadow influence.
So someone who might not have been involved in the actual incorporation, but maybe they're a major financier or a strategic consultant, and whatever they say, the board just does it. That person could suddenly find themselves with promoter liability.
Exactly right. Our source material points out a crucial insight here. The statement, to be a promoter, one must necessarily be associated with the initial formation of the company, is false.
I see.
Someone who comes in years later, maybe to manage a critical round of funding, and the board consistently acts on their financial advice, that person is legally a promoter. This is what you have to grasp for a professional analysis.
But what about the people who are just doing their jobs? You can't have lawyers or auditors suddenly becoming promoters just because the board takes their advice.
And that's the key exclusion. The law is very clear. It explicitly states that this definition shall not include a person acting merely in a professional capacity.
So your attorney, your consultant, your auditor.
They're all shielded. Their advice, while influential, is given as part of a defined professional service. They aren't exercising core control over the company's actual direction.
That sets a clear boundary. Okay, so let's move from the individuals to the entity they're creating. Under Section 3, how many people does it take to get these different corporate forms off the ground?
Section 3 sets those minimum membership requirements. They're the initial gateways to corporate status. For a public company, you need 7 or more persons.
Okay.
For a private company, you need 2 or more. And for the newest, most streamlined structure, the one-person company or OPC, it's just 1 person.
And beyond the headcount, Section 3.2 also classifies them by the 3 primary forms of liability. This really dictates the financial risk for the members.
Right. The 3 types are companies limited by shares, companies limited by guarantee, or companies with unlimited liability. It's also important to remember they're not always mutually exclusive. You can have a company limited by guarantee that also had share capital.
Okay.
And we should note, International Financial Services Center companies, so those in zones like Gift City, they have to be formed as a company limited by shares. That's a strict requirement for them.
Let's dedicate some serious detail to the one-person company. This is governed by Section 31C and Rules 3 and 4. This really revolutionized small business incorporation, didn't it?
It did. It granted limited liability to a single entrepreneur. But the OPC is a modern concept that comes with some very tight restrictions.
Such as?
Eligibility. It's confined to a natural person who must be an Indian citizen. They can be resident in India or otherwise. That's a significant clarification that was introduced. But critically, minors are totally excluded. They can't be a member and they can't be a nominee.
The residency detail is precise. What defines resident in India in this context?
For OPC purposes, a person is a resident if they have stayed in India for a period of not less than 120 days during the immediately preceding financial year. It's a clear, objective metric.
And what about restrictions on what an OPC can actually do?
The law keeps the OPC focused on standard commercial activity. First, an OPC cannot be incorporated or later converted into a Section 8 company, so it can't be a not-for-profit, ever.
Right.
And second, it's barred from carrying out non-banking financial investment activities. This includes investing in securities of other companies. It prevents the OPC structure from just being used as a simple, single-person investment vehicle.
That makes sense. But given that it has only one member, how does the law handle the fundamental requirement of perpetual succession? If the sole member dies or becomes incapacitated, the company has to continue.
And that's the clever mechanism built into the OPC structure, the nominee. The Memorandum of Association must name another natural person, again, an eligible Indian citizen who acts as the nominee, and that person has to give their prior written consent in Form INC-4.
And what triggers that transfer of membership?
The nominee steps in automatically. They become the member of the company upon the subscriber's death or their contractual incapacity, like being declared insolvent. The classic example in our sources is Ms. Madhu, the original member, nominating Mr. Sudan. If Ms. Madhu passes away, Mr. Sudan instantly becomes the member. The corporate veil is never dropped.
The structure seems like it could be abused if one person could just run 20 different OPCs, each with limited liability. How does the law prevent that?
It uses extremely strict constraints under Rule 3. A natural person shall not be a member of more than one OPC at any point in time.
Okay, one per person.
And they can't be a nominee of more than one OPC at any point in time. It's a dual restriction.
So what if a situation accidentally arises? So you're the member of OPCA, and the member of OPCB dies, and you were their nominee. Suddenly you're a member of two. You're in violation.
The law recognizes that this can happen involuntarily, so it gives you a grace period of 180 days. In that time, you have to meet the single-member criteria again. You either have to convert one of the companies or sell your interest to get back into compliance.
Let's talk about the nominee role itself.
Mm.
Is it set in stone? What if the current nominee, Mr. Sudan, decides he doesn't want the responsibility anymore?
He can withdraw. He just has to give notice in writing to the sole member in the company. The sole member then has a very brief window, just 15 days, to nominate a new person.
And if the sole member, Ms. Madhu, wants to replace the nominee, maybe she loses confidence in them, or like in the Rajesh and Rupali example, the nominee becomes incapacitated?
The sole member can change the nominee at any time, for any reason. They just need to get the prior written consent of the new nominee and inform the company.
And in all these cases, withdrawal, replacement, what's the compliance step?
In every single instance, the company has to file the change with the registrar. They use Form INC-4, and they have to do it within 30 days of receiving the notice.
Hold on a second. The nominee's name is in the memorandum. Usually, changing the MOA is a huge deal. It requires a special resolution, maybe even government approval. Does changing the nominee trigger all of that?
This is a critical point, and it shows the regulatory flexibility for OPCs. The source material is explicit. Any such change in the name of the nominee shall not be deemed to be an alteration of the memorandum.
So it's a statutory carve-out.
It's a statutory exemption, yes. It's designed to simplify the administrative burden on OPCs so they don't have to go through a major constitutional amendment every time the nominee changes.
That makes perfect sense.
Yeah.
Are there other big administrative breaks that OPCs get?
Oh, yes, several. The annual return can be signed by just the director. The requirement to hold an annual general meeting, an AGM, is completely waived.
Wow, no AGM.
None. And for board meetings, they only need to hold one in each half of a calendar year with a gap of at least 90 days between them. And they get 6 months from the end of the financial year to file their financial statements.
Okay, here's where it gets, I think, really interesting and honestly, quite serious. Moving beyond the OPC, what are the consequences if a public or private company fails to maintain its minimum membership under Section 3A? This is where limited liability can just evaporate.
It really can. This is Section 3A, and it's where the personal liability hammer drops.
So what's a trigger? Let's say a private company with 2 members, one of them leaves, now they're down to 1.
Okay, so the clock starts ticking. The law gives them a grace period, a pretty generous one, actually.
How long?
6 months. For 6 months, the company can continue to trade, and the remaining member's liability is still limited. They're expected to find a new member or, wind up.
But what if they don't? What if they just keep going after that 6-month window closes?
That's the trigger. If the company carries on business for more than 6 months with reduced membership, then every member who is, and this word is key, cognizant.
Aware, they have to know they're breaking the rule.
Exactly. If they are aware of the fact, then they become severally liable, personally liable.
For all the company's debts.
That's the crucial detail for a professional. Not for all of them. Only for the whole debts of the company contracted during that time.
So only for the new debts incurred after this 6-month grace period has expired.
Precisely. The protection is gone for any new business they do from that point forward. Their personal assets are now on the line. They can be severally sued. The law is forcing accountability when limited liability is abused.
Now we move to the foundational documents that give the company its structure, its identity, its rules, often called the Bible and the Rule Book, the Memorandum of Association, or MOA, and the Articles of Association, the AOA.
Let's start with the MOA. That's Section 4.
And this is the charter or constitution, the document that defines the company's relationship with outsiders.
Yes, the MOA is the external document. It is paramount because it sets the operational boundaries, the scope of powers, and the relationship with the outside world. It's the foundation for the doctrine of ultravirus, which we'll get into.
We need a granular breakdown. What are the 6 mandatory clauses of the MOA under Section 4.1?
Okay, first up, the name clause. The company has to put limited or private limited at the end of its name.
Unless it's a Section 8 company.
Right, a nonprofit.
Right.
And remember, IFSC companies must use the suffix IFSC.
The law is very strict here to avoid public confusion.
Yep.
What makes a name undesirable under the Act?
It falls into 2 main buckets. First, resemblance. A name is undesirable if it's identical to an existing company name or resembles it too closely.
To avoid someone trying to piggyback on an established brand.
Exactly. The second is misuse of authority. The name can't contain words that suggest a connection with the government or statutory bodies like national or union or minister without getting prior approval from the central government.
What are the specific rules of resemblance the ROC uses? This is where the devil is really in the detail.
The ROC is looking for the intent to confuse the market, so they disregard differences based on things like plural versus singular. So green tech is treated as similar to Green's technology.
Okay.
Punctuation and spacing don't matter. ABC Ltd is the same as ABC Ltd. Different verb tenses don't work either. Ascend Ltd is similar to Ascended Ltd.
And what about phonetic spelling? That seems like a common trick.
It is, and they catch it. BK Services is considered similar to BK Services. They're trying to stop companies from registering the same brand name with creative spelling. Same goes for adding a domain suffix. Ultrasolutions.com is no different from Ultrasolutions Ltd.
That prevents a lot of easy workarounds. How about numbers?
Adding or changing numbers is generally seen as similar, unless the number itself represents a known brand. Thunder Services is seen as similar to Thunder 11 Services.
Once a name is approved, how long is it reserved for? And what happens if someone used fraudulent information to get it?
Name reservation is for 20 days initially, but you can pay to extend it up to 60 days. And the law is very strict on fraud. If you furnished wrong information and the company hasn't been incorporated yet, the registrar can just cancel the reservation and fine you up to 1 lakh rupees.
And if the company was incorporated?
Then the registrar can take action against the company itself, maybe forcing a name change or even dissolving it.
Let's move to the situation clause. Why is just naming the state in the MOA good enough? And what legal function does that serve?
Naming the state establishes the company's legal domicile. That's foundational. It immediately tells you which ROC, which regional director, which court has jurisdiction. The specific physical register office address then has to be established within 30 days of incorporation.
Okay, next, the object clause. This feels like the heart of the company's purpose.
It is. It states the primary objects for which the company is formed and any ancillary matters. This clause is the ultimate legal boundary. If you step outside it, You're committing an act of ultra-virus.
Now, the liability clause. Can you detail the difference in liability exposure for a company limited by shares versus one limited by guarantee?
For a company limited by shares, a member's liability is strictly limited to the amount, if any, that's still unpaid on the shares they hold.
Right. The example of Mr. Sanju owning shares at a 10 rupee face value, having paid 8, is perfect. His total risk is just 2 rupees per share. That's it.
That's the essence of it. Now contrast that with a company limited by guarantee. Here, the liability is the specific amount each member agrees, in the MOA, to contribute to the company's assets, but only if it's being wound up.
And within that guarantee structure, we have to understand the difference between List A and List B members during liquidation.
Yes, this is a nuanced point. List A members are the current members. They're on the hook first. List B consists of former members who left within the 12 months before the winding up started.
So they have a look-back period.
Exactly. They are secondarily liable. They're only called upon if the money from List A isn't enough to cover the debts that were contracted before they left. It stops members from jumping ship right before collapse to escape their obligation.
The final clauses are administrative, but still essential. The capital clause and the subscription clause.
The capital clause specifies the authorized capital, the maximum the company can issue, and how it's divided. It also requires every subscriber to take at least one share. The subscription clause just lists who the subscribers are and how many shares they've each agreed to take. And of course, the nomination clause is only for OPCs.
And the formats for these are all standardized, right?
Yes, in Schedule I to the Act, tables A through E, depending on the type of company.
Okay, let's move inside the corporate structure to the internal rulebook. The Articles of Association, or AOA, that's Section 5, what's in them, and how does this crucial concept of entrenchment work?
The AOA contains the internal rules for day-to-day management. It defines the relationship between the company and its members and, very importantly, between the members themselves intersisting.
Entrenchment is basically building a legal firewall around a specific rule, making it incredibly hard to change. Why would a company do that?
It's often to protect minority rights or core structural agreements. For example, in a small private company, a founder might use entrenchment to say that a decision that normally needs a 75% majority, a special resolution, instead requires a 90% or even 100% majority. It makes certain provisions really rigid.
And how do you legally include this high standard of rigidity?
It has to be done with the highest level of agreement. You can either do it right at formation, when the company is being created, or you can add it later by amendment.
If it's done later.
If it's done later, a private company needs the agreement of all its members. Unanimous consent. A public company can do it with a special resolution. And in both cases, you have to notify the registrar so that outsiders are on notice that these internal rules are tougher than usual.
Let's synthesize the relationship between the Act, the MOA, and the AOA. Where does the ultimate authority lie?
The authority is strictly hierarchical, and it's defined by Section 6, supremacy of law. The Act is supreme, period. Any provision in the MOA, the AOA, or any agreement that contradicts the Companies Act is void.
Can you give us a clear example of that?
Sure. An AOA can't say that directors can pay dividends out of capital because the Act strictly forbids it. The Act says dividends only come from profits, so that article in the AOA would be totally void.
And between the MOA and the AOA, which one wins?
The MOA is the charter, so it's supreme over the AOA. The MOA defines the external scope. The AOA just manages the company within that scope. And this is vital for the legal doctrines we'll discuss. An act that's ultra-vires the MOA is void and can't be fixed. An act that's ultra-vires the AOA can often be fixed or ratified by the shareholders.
Finally, what's the binding effect of these documents once they're registered under Section 10?
Upon registration, the MOA and AOA legally bind the company to its members and the members to the company as if everyone had personally signed them. It creates a contract. So if a member doesn't pay a call on their shares, the company can sue them for that money as a contractual debt.
The Rayfield v. Hands case showed it also binds members to each other, right?
It did. The article said existing directors had to buy the shares of any member who wanted to sell, and the court enforced that between the members.
But the AOA is an internal document. You can't bind the company to an outsider, can it?
That's the crucial limitation. Established in Brown v. La Trinidad, no article can create a contract between the company and a third party. So even if an article promises an outsider a job for life, that outsider can't sue the company to enforce it based just on the AOA.
We've established the foundational rules. Now let's get into the actual birth process. How do you go from documents to a legal entity, This is the incorporation procedure under Section 7, with a focus on modern tools.
The process has been massively streamlined with the integrated web form SBICE plus MES. That stands for Simplified Pro Forma for Incorporating Company Electronically Plus.
A bit of a mouthful.
It is, but it bundles multiple services into one: name reservation, DI allocation, PAN, TAN, even EPFO registration. It's a single gateway.
What are the key filings that guarantee the integrity of the process?
Integrity is the focus. You have to file the signed MOA and AOA. Subscriber signatures need a witness. If a subscriber is another company, you need a resolution authorizing their representative. And for foreign nationals, signatures have to be notarized and, in some cases, authenticated by a diplomatic officer.
That locks down accountability. What about the declarations?
Two critical declarations. First, the Declaration of Compliance. This has to be signed by a professional, a CA, CS, an advocate, confirming that all legal requirements have been met.
And the second?
The second is a declaration by the subscribers and first directors themselves in Form INC 9. They have to state, under penalty of perjury, that they haven't been convicted of any promotion or management offenses and haven't been found guilty of fraud in the last 5 years.
You also need the particulars of the first directors.
Correct. Their consent in Form DIR2, which includes their DIN, PAN, identity proof, address, and so on. And finally, you have to declare if you need any approvals from sectoral regulators like the RBI or SEBI based on what the company plans to do.
Once all that is accepted, the registrar issues the Certificate of Incorporation, the COI, and the company gets its unique ID number.
Right. The registrar allots the corporate identity number, or CIN. It's a 21-digit alphanumeric code, and it has to be on the COI.
Let's break down the info packed into that CIN, using the Infosys CIN as our guide. L851WO KA181 PLC 013115.
This is essential professional knowledge. The L at the start means it's a listed company. U would be unlisted.
Okay.
85110 is the 5-digit industry code. KA is the state of registration, Karnataka. 1981 is the year of incorporation.
Simple enough.
PLC means it's a public limited company. And the last 6 digits, 013115, that's the unique registration number from that specific ROC.
Once that COI is issued, Section 9 confirms the company is now a separate legal entity with perpetual succession, able to own property, sue, and be sued.
The COI is the birth certificate. It establishes the corporate personality. But, and this is a huge change in the 2013 Act, the COI is no longer considered conclusive proof that everything was done correctly.
It's not conclusive proof. Why the change from the old law?
Because of the severe consequences for filing false information, which are detailed in Section 7, 6, and 7, the new law is laser-focused on prosecuting fraud at the very beginning.
So if it's discovered after the COI is issued that someone lied on the application, the COI doesn't protect them.
Not at all. The consequences are immediate and severe.
What are the specific liabilities for the people involved in that fraud?
The promoters, the first directors, and the professionals who sign the compliance declarations are all liable for fraud under Section 447. That is one of the most punitive sections in the Act. It carries heavy fines and potential jail time.
And what can the tribunal, the NCLT, do to a company that was born from fraud?
The NCLT has immense power. It can order the regulation of the company's management, it can force changes to the MOA and AOA in the public interest, and in the most serious cases, it can just order the winding up of the company. It can effectively revoke its existence.
So getting the COI is necessary, but it's not sufficient proof of a fully legal foundation. We have the birth certificate, but when can the company actually start doing business? That brings us to Section 10A, commencement of business.
Right. Section 10A applies specifically to companies that have a share capital and were incorporated after the 2019 amendment. This section makes sure companies are not just legally registered, but also financially functional before they start trading or borrowing money.
What are the 2 mandatory conditions that have to be met within 180 days of incorporation?
First, the company has to file the verification of its registered office address. And second, a director has to file a declaration, Form INC 20A, stating that every subscriber has paid the value of the shares they agreed to take. This proves the company has its seed capital.
And what if they don't file that declaration within the 180-day window? The consequences seem pretty brutal.
They are. The penalty structure is designed to force compliance. The company gets a 50,000 rupee penalty, and every officer in default gets fined 1,000 rupees per day.
1,000 a day.
But the most severe consequence is the threat of dissolution. If that declaration isn't filed in 180 days, the registrar has reasonable cause to believe the company is inactive and can start the process of striking its name off the register.
Let's shift our focus now to Section 8 companies, the not-for-profit entities. Their legal existence isn't about capital, it's about a charitable mission.
Exactly. Their objects have to be the promotion of commerce, art, science, sports, education, social welfare, charity, things like that. They exist for the public good, not for private gain.
And they operate under a license from the central government.
Yes, though that power is usually delegated to the ROCs and regional directors.
What are the two non-negotiable core conditions that a Section 8 company absolutely has to satisfy?
These are the heart of their mandate. First, the company must apply all its profits and income only to promoting its objects. Every rupee earned goes back into the mission.
No siphoning off profits.
None. And second, the company must strictly prohibit the payment of any dividend to its members. The members cannot profit from their membership.
We know OPCs can't be Section 8 companies. Are there other structural differences?
Yes, a key one is that a firm, like a partnership, can be a member of a Section 8 company, which is an exception. Also, their CIN will have NPL in it, for a not-for-profit license company.
Given that their existence is tied to this public interest license, I'm guessing that altering their MOA and AOA is a lot harder than for a normal company.
Much harder. They need external government validation. To alter the memorandum, you need prior permission from the regional director. To alter the articles, you need prior permission from the Registrar of Companies. The government keeps them on a very tight leash.
What's the procedure if a Section 8 company decides it wants to convert into a regular for-profit company?
The procedure is extremely stringent because you're moving assets out of the nonprofit sphere. They have to pass a special resolution with a detailed explanation. Then they apply to the regional director.
And here's the critical part, I imagine.
It is. The company has to serve written notices to a whole range of authorities. The income tax commissioner, the charity commissioner, the chief secretary of the state. These bodies get 60 days to object. They also have to publish public notices in newspapers.
And the regional director only approves if what conditions are met?
The RD has to be satisfied that the conversion is justified and that the company has either gotten consent from all its creditors or has provided adequate security to pay off all its debts. Public interest and creditor rights are paramount.
Now, what if a Section 8 company goes rogue? It starts paying a dividend illegally or operates fraudulently.
The consequences are severe. The central government can revoke their license.
And what happens immediately when the license is revoked?
The registrar immediately adds limited or private limited to the company's name on the register. It loses its nonprofit status instantly.
And the final orders.
The government can then direct one of two things. Either the company is wound up and any surplus assets are transferred to another Section 8 company, or the insolvency and bankruptcy fund.
So no one profits.
No one. Or they can be forcibly amalgamated or merged with another Section 8 company that has similar objects.
And the financial penalties are substantial.
Huge deterrence. The company can be fined up to 1 crore rupees. The officers in default face fines up to 25 lakh rupees, plus personal liability for fraud under Section 447.
We've built the company structure. Now let's look at the legal rules governing who can walk through the door and how they must behave. This is the section that truly defines corporate liability. The 3 essential legal doctrines.
This is where high theory meets daily commercial practice. We have to start with the doctrine of ultravirus.
What's the definition, and what is the absolute non-negotiable consequence of an act being ultravirus the MOA?
Ultravirus literally means beyond the powers. It states that any act done by the company that is beyond the scope of its objects, as stated in the MOA, is absolutely void. It's a nullity from the very beginning.
And what makes this different from other legal breaches?
Its irreversibility. The key case here is Ashbury Railway Carriage and Iron Co. Ltd. v. Riche. The company contracted to finance a railway in Belgium, which was totally outside its object clause. The House of Lords said the contract was void, and crucially, it could not be ratified.
Not even if every single shareholder agreed to it.
Not even then. It remains ultravirus forever. Even if you change the MOA later, that only works for the future. It can't fix the past.
So if a company set up to provide IT services signs a contract to buy a fleet of fishing trawlers, that contract is worthless. Neither side can enforce it.
Correct. The MOA is public notice of the company's limits.
We have to clearly distinguish an act that is ultravirus the MOA from one that is merely ultravirus the directors or the AOA.
This distinction is paramount, an act that's just beyond the director's authority or violates the AOA. For instance, directors borrowing too much money without shareholder approval. That can often be fixed. It can be ratified by the shareholders with a resolution as long as the act itself is still within the scope of the MOA. A violation of the MOA is fatal. A violation of the AOA is often fixable.
Okay, so the ultravirus doctrine protects investors and creditors by locking the company into its stated purpose. But if outsiders claim they didn't know the rules, how does the law protect the company? That's the defensive shield of the doctrine of constructive notice.
Yes, this doctrine places the burden of due diligence squarely on the outsider. Since the MOA and AOA are registered public documents, every person dealing with the company is legally presumed to have read and understood them.
It's a legal fiction. The law treats you as if you know every detail, even if you've never seen the documents.
Exactly. Your ignorance is no excuse. If an outsider enters into a contract that violates a public document, they can't claim relief against the company.
The modern furniture check example illustrates this perfectly. The AOA says 2 directors must sign any check over 1 lakh. A supplier accepts a check for 2.2 lakh, signed by only 1 director.
The supplier is legally presumed to know that internal rule. When the company refuses to pay because the rule was broken, the supplier can't sue. The company uses constructive notice as a shield.
It is often called an unreal doctrine because nobody in the real world stops a deal to go read 50 pages of articles of association.
And that is precisely why the law developed a counter-doctrine. If constructive notice is the company's shield, then the doctrine of indoor management, or Turquoine's rule, is the honest outsider's sword.
Okay, so if constructive notice puts all the burden on the outsider,
Right, which can feel really unfair.
then there must be something to protect them, right?
There is, and it's called the doctrine of indoor management. You'll also hear it called Turquoine's rule, from the classic case, Royal British Bank v. Turquoine.
And what's the core idea?
It basically says that outsiders dealing with a company are entitled to presume that all the company's internal proceedings, the things they can't see, like board resolutions, have been done correctly.
So in the Turquoine case, the company's articles allowed directors to borrow money, but only if they were authorized by a resolution.
Right, and the lender, the outsider, saw the articles and knew the power existed, but he didn't check if the internal resolution had actually been passed.
And the court said he didn't have to.
Exactly. The court said he was entitled to presume that the internal requirement had been met. The internal management of the company is not the outsider's responsibility.
So indoor management protects the honest outsider from the company's own internal chaos. But the law only protects the innocent outsider. When is this doctrine denied?
Relief is denied in 4 specific situations where the outsider can't reasonably claim innocence. First, if they have actual knowledge of the irregularity. If you know the meeting was never held, you can't claim protection.
Okay, that's obvious. What's next?
Second, suspicion or negligence. If the circumstances are so suspicious that they invite inquiry, the law says you were negligent for not investigating. For example, if the company accountant tries to sell you company property, that's unusual. You should ask for a power of attorney.
Right.
Third is forgery. The doctrine does not apply to forgery. A forgery is a complete nullity. It's not just an internal irregularity. In the Rubin v. Great Fingal case, the secretary forged directors' signatures on a share certificate. The outsider couldn't force the company to accept it as genuine.
And the last one.
The last one is if the act itself is ultra vires the company. Beyond the scope of the MOA, indoor management can't save a deal that was void from the start.
The founding documents aren't static. Let's move to the mechanics of altering them, starting with the MOA under Section 13. All alterations need a special resolution and filing with the registrar.
That's the general rule, SR and filing form MGT14. But the complexity is in the specifics for each clause, especially when the public interest or creditors are involved.
Let's detail the alteration of name.
This requires an SR and central government approval, which is delegated to the ROC. And the change is only effective when the ROC issues a fresh certificate of incorporation. The law also says a company can't change its name if it's behind on filing its returns or has defaulted on paying its debentures.
That prevents a company from changing its identity to run from its problems.
Exactly.
What about name rectification under Section 16? This is when the government forces a change.
Yes. If the regional director finds a name is too similar to an existing company or a registered trademark, they can direct the company to change its name within 3 months. And for this, you only need an ordinary resolution. The key detail for trademark owners is that they have a 3-year window to apply.
Now, for the complex scenarios, alteration of the registered office, there are 3 different situations.
Right. If you're just shifting within the same city, that's easy. Just a board resolution and a filing. If you shift outside the city but stay in the same state and under a new ROC, you need a special resolution and confirmation from the regional director. But the most complex move is shifting from one state to another.
Which requires altering the MOA itself.
Yes. For interstate shift, you need a special resolution and approval from the central government, again, the ROD, and the procedure is highly regulated to protect creditors. The application has to include a full list of all creditors. The company has to advertise the proposed shift in newspapers. The ROD has to make sure that every creditor has either consented or the company has made adequate provisions to pay off their debts.
And once the RD approves,
You file the order with the ROC of both states. The new ROC then issues a fresh certificate of incorporation, and only then is the change legally effective.
the final major MOA alteration is the object clause, specifically if the company raised money from the public and has unutilized funds. This feels like a huge investor protection rule.
It is. It's all about investor trust. If a company used a prospectus to raise funds and still has that money, it can't change its objects without meeting 2 severe requirements. First, the special resolution must be passed via postal ballot.
To ensure maximum shareholder participation.
Right. And second, any dissenting shareholders, the ones who vote against the change, must be given a clear opportunity to exit. The promoters have to buy them out, according to SEBI regulations.
So you can't take money for one project and then just decide to do something else without letting the original investors out.
Exactly right.
Moving to the internal rules. Alteration of articles, the AOA.
The company has the power to alter its AOA by special resolution as long as it doesn't violate the Act or the MOA. But if the alteration leads to converting the company's class, you need more.
What are the requirements for converting a public company into a private company?
This needs a special resolution, but it's not valid unless it gets prior approval from the regional director. The RD's approval is a necessary condition before the conversion can happen.
Once changes are made, the company has to make sure everyone is reading the correct rulebook.
That's Section 15, updation of copies. Every alteration made must be noted in every single copy of the MOA and AOA that's issued. The penalty for failing to do this is 1,000 rupees per incorrect copy.
Let's finalize with the administrative and structural rules. First, the registered office.
The physical presence is mandatory. The RO has to be established and verified within 30 days of incorporation. And under Section 12(3), the company name and address must be painted or affixed outside every office in a conspicuous place.
And OPCs have that extra labeling requirement.
Yes, they must add one-person company in brackets below their name everywhere it appears.
Now, for a key structural constraint, a subsidiary cannot hold shares in its holding company. That's Section 19. What's the logic here?
The logic is to prevent the holding company from indirectly controlling itself. If its subsidiary could vote at its meetings, the holding company could entrench its own management and manipulate shareholder democracy. So any such transfer of shares is void.
But there are 3 crucial exceptions where a subsidiary can hold shares in its holding company.
Yes. First, if it holds them as a legal representative of a deceased member. Second, if it holds them as a trustee. And third, if it acquired the shares before it became a subsidiary.
And the distinction in voting rights here is absolutely vital.
It is. Voting rights are only available in the first 2 cases, as a legal representative or a trustee. In the third case, where it was a pre-existing shareholder, it can continue to hold the shares, but it has no right to vote.
Finally, let's cover the authority for corporate signatures, specifically the execution of deeds under Section 22. The Parag Constructions example showed that implied authority isn't enough for formal legal documents.
That's the entire point of Section 22. It mandates formality. For a formal deed, like a partnership deed, it must be executed by a person authorized in writing as an attorney.
And how must that formal authorization itself be executed?
It has to be either under the company's common seal, if it has one, or R signed by 2 directors, or R by 1 director and the company's secretary. Because the director in that example just relied on his implied authority, the company could legally deny the deed. It's a critical technical distinction.
We have completed a deeply technical dive from the promoter's idea right through incorporation, the social mission of Section 8 companies, and the protective walls built by these legal doctrines. We've seen how Indian company law prioritizes structure, transparency, and accountability.
The core takeaway is the meticulous nature of it all. Remember the hierarchy. The act is supreme, then the MOA, then the AOA. For professionals, mastering the difference between an act ultravires the MOA, which is void, and an act ultravires the AOA, which is potentially fixable, is non-negotiable.
And that legal tension between constructive notice, which presumes you know the rules, and indoor management, which protects the innocent outsider from internal messes, is absolutely central to understanding corporate liability.
And we saw how the 2013 Act really bolstered enforcement, especially through the NCLT's power to intervene when there's fraud, and the punitive measures in Section 10A tying the start of business to actual paid-up capital. The law insists on financial readiness as much as formal legal existence.
So what does this all mean? For anyone in the corporate landscape, understanding these foundation documents isn't just theory. It's the difference between a valid transaction and a void act that could expose your clients to crippling personal debt under Section 3A.
And this leads us to a final thought for you to consider. If the purpose of the doctrine of indoor management is to protect the innocent outsider from internal irregularities, they can't reasonably check, like whether a resolution was passed. Does the rising use of public electronic documentation, like filing the full text of resolutions in Form MGT-14, fundamentally erode the need for the doctrine entirely?
Or does it just shift the legal scrutiny to the legitimacy and validity of those digital filings themselves, creating a new form of indoor management risk? Something to mull over in your next deep dive. Thanks for joining us.